Hello, everyone. Thank you to almost 500 participants joining us today for this expert roundtable on the Ukraine-Russia conflict and the role of international law in this situation. My name is Milena Stereo, and I'm the Managing Director at the Public International Law and Policy Group, and also the Charles R. Emmerich Jr., Calfee, Halter, and Griswold Professor of Law at Cleveland State University's Cleveland Marshall College of Law. I will be moderating today's discussion, and I'm honored to be guiding the conversation with these experts. The Public International Law and Policy Group is a global pro bono law firm providing free legal assistance to parties involved in peace negotiations, drafting post-conflict constitutions, war crime prosecution, transitional justice, and human rights documentation. Over the past year, our team has been fostering the development of a thought leadership initiative. This initiative focuses on a range of topics, from prominent international law issues to pressing global conflicts. Through organizing periodic roundtables, our aim is to share expertise and reflections from our work on peace negotiations, post-conflict constitution drafting, and war crimes prosecution. The Ukraine-Russia crisis has been on the headlines of all newspapers for the past few days. On February 24th, 2022, Russia launched a full-scale invasion of Ukraine by air, by land, and by the sea. Minutes before the invasion, Russian President Vladimir Putin declared war and said that they're prepared for everything if other states threaten Russia. States all over the world have imposed fierce sanctions against Russia and called out Russia for blatantly violating international law. NATO has also taken steps to bolster its defense in Eastern Europe. Many international lawyers have been watching these developments, thinking about the role of international law and the United Nations Charter system, and what role they play in this situation, and what should be the response to these violations of international law. The Public International Law and Policy Group, as part of its support to transitional justice and peace building in Ukraine, recently implemented a transitional justice, human rights documentation, and peace-building training for Ukrainian civil society organizations and civil servants from the Ukrainian Ministry of Reintegration of the temporarily occupied territories. This training was part of PILPG's wider support for transitional justice and peace-building efforts in Ukraine, whereby PILPG provides technical support to Ukraine civil society and civil servants for the establishment of a peace-building center and transitional justice legislation. Recently, the Public International Law and Policy Group has also launched a website to aid civil society organizations and other actors documenting human rights abuses in Ukraine. The purpose of this portal is to provide capacity building for civil society organizations and individuals seeking to document the atrocity crimes and human rights violations being perpetrated in Ukraine. This website will be continually updated with additional high-quality open source resources from PLPG and our colleagues in the fields of accountability and human rights documentation. During today's event, we will be discussing just that, how international law fits into this situation, what are the legal issues we're looking at now, and what should be the international response to this situation. The roundtable will be 60 minutes long. Our esteemed panelists include Dr. Yvonne Dutton, Dr. Margaret de Guzman, Ambassador Stephen Rapp, and Professor Jennifer Trahan. Today's event will be recorded and subsequently posted on our website. We ask that you please submit any questions you have for our speakers using the Q&A function, and we will do our best to answer your questions at the end of this event. Now, let me begin by introducing our panelists. First, we're excited to welcome Dr. Yvonne Dutton, Senior Legal Advisor at the Public International Law and Policy Group and a Professor of Law at the Indiana University Robert H. McKinney School of Law. Professor Dutton has recently been involved with providing technical assistance with the development of framework laws on transitional justice and the harmonization of Ukrainian domestic law with international humanitarian law and the drafting of a legal charter for the Ukrainian Peace Building and Documentation Center. Also joining us today is Dr. Margaret de Guzman, Senior Legal Advisor at the Public International Law and Policy Group, and James E. Beasley Professor of Law at Temple Law School and co-director of Temple's Institute for International Law and Public Policy. Dr. de Guzman was also recently appointed by the Secretary General of the United Nations to the roster of judges of the International Residual Mechanism for Criminal Tribunals. She was also part of the PILPG team that worked with civil society organizations in Sri Lanka on documentation, reporting, government engagement, advocacy, and community building. I'm honored to welcome Ambassador Stephen Rapp, Senior Peace Fellow at the PILPG and a Senior Visiting Fellow of Practice with the Blavatnik School's Institute for Ethics, Law, and Armed Conflicts Program on International Peace and Security. He also currently serves as Distinguished Fellow at the United States Holocaust Memorial Museum Center for Prevention of Genocide and as Chair of the Commission for International Justice and Accountability. From 2009 until 2015, he was Ambassador at Large, heading the Office of Global Criminal Justice in the US State Department. Ambassador Rapp is also actively commenting on the media about the war in Ukraine. And we also have Professor Jennifer Trahan, Senior Peace Fellow at the Public International Law and Policy Group and a professor at NYU Center for Global Affairs, where she directs the concentration in international law and human rights. And she's also the convener of the Global Institute for the Prevention of Aggression. She's published numerous law review articles, books, and book chapters, including on the International Criminal Court and in particular on ICC's crime of aggression. For full speaker biographies, please see the link sent in the Zoom chat and also visit the PILPG website. Welcome everybody, and thank you for agreeing to participate in today's panel. My first question goes to Yvonne. Yvonne, could you give us some additional background on how we got to where we are today? What are some key events that led up to the outbreak of the war last week?
Sure, thanks, Milena. I'm just going to sort of talk a little bit and briefly about NATO and Ukraine and a little bit about the EU and Ukraine, just sort of some of the things that seem to be in the background that have allegedly, served as the reasons for this invasion, right? So in 2008, there was a Bucharest summit and, where NATO member states discussed some membership possibilities for Georgia and Ukraine. They did not become members at that time. And I will talk about how Ukraine has continued to seek some membership with NATO. One of the things about NATO membership that is relevant to this discussion about international law, and that we'll probably talk about, is that one of the agreements with NATO membership is that if one member state of NATO is attacked, then all of the other members must defend that one member state. And this is in Article 5 of NATO. Now, Ukraine has also had some relationships with NATO in terms of some other sort of agreements to sort of assist it in its efforts to sort of have some sort of alliance with Europe. There's a little bit of practical support for Ukraine set out in, for example, a comprehensive assistance package for Ukraine. In 2017, the Ukrainian parliament adopted legislation reinstating membership in NATO as a strategic foreign and security policy objective. So that's very recent, right? And then in 2019, there was a corresponding amendment to Ukraine's constitution that entered into force, again, looking forward to this NATO membership. Then we had in September of 2020, President Zelensky approved Ukraine's new national security strategy, which provides for the development of the distinctive partnership with NATO with the aim of eventual membership for Ukraine in NATO. Also, aside from NATO, Ukraine has sought and continues to seek some membership in the European Union as well. Now, how does the NATO membership and Europe, et cetera, relate to the current events that we know about with Russia's invasion? Well, Russia has, what we're hearing is Russia is taking this, what it calls the NATO expansion, considering that and alleging that that is some sort of attack on its own security. Russia, Putin, argues that they received some promises in the early 1990s, after the collapse of the Soviet USSR. They claim that they received some promises that NATO would not expand eastwards towards Russia any further. And yet, Poland, Czech Republic, some Baltic states, et cetera, have become members of NATO. This is Russia's allegation that this was a promise. Others say that this was not a promise and it is not in writing. What did happen in the 1990s, also with the fall of the USSR, was that Ukraine did have nuclear weapons on its territory that it gave up in exchange for a promise by Russia not to invade its territorial integrity. Now, what we've also seen in recent months or years is Russia is demanding that NATO provide guarantees that Ukraine will never get to join. It's also talked about not, de-admitting the states that have been admitted, right? So that's where we are sort of with NATO. A couple of other things that have happened recently, and we can talk more about this if need be, but just to set the stage, there has been conflict ongoing with Russia attacking Ukraine and some of its territories. Starting in 2014, for example, it annexed Crimea. Russia also assisted back in 2014 the Russian separatists in the Luhansk and Donetsk region that were occupying those territories and engaged in conflict there. To aid in stopping that conflict that was ongoing beginning in about 2014. Some states assisted in negotiations for peace between Russia and Ukraine, which resulted in these Minsk Accords, which we've been calling Minsk I and Minsk II of 2014 and 2015. Nevertheless, as a result of those accords, there was supposed to be a ceasefire, but it hasn't quite played out that way. We can talk more about that. As everyone knows from reading news accounts, in the past 6 months or so, there has been an enormous military buildup beyond what was there for these conflicts that began in 2014, such that there were some 190,000 troops on the borders of Ukraine. And one thing that I think we will also talk about today is one of the recent events before the full-scale invasion was that in February, on the 21st of February, Russia then recognized the Luhansk and Donetsk as independent states, which form the basis for part of its alleged reasons for intervening. So I think I'll leave it there, Milena, because I'm sure you have a lot of other points that you'd like to follow up on.
Sure. Let me go to Jennifer next. So Jennifer, where are we today? What is going on, today as we speak? Some of these developments really happen by the minute, but as of, sort of this morning, what has happened?
Unfortunately, I was on a faculty meeting this morning. Thank you for that. Just to say, I mean, we're dealing with a flagrant violation of the UN Charter, and I think that's the most fundamental thing here to make clear. And I appreciate Yvonne provided us a lot of the context, but just to be very clear to anyone who might not be familiar, that your neighbor might be joining NATO or is in discussions is not a reason to violate the UN Charter, nor can you claim, oh, these parts of another state are a separate state and, justify intervention on those grounds. So, we are hearing from Russia a number of arguments that sound like international law. They're used in like international law terminology and, they just don't fit. We had a full-scale invasion, and I think that's the most important point. And I think we want to discuss accountability about that. And, just to say it's a flagrant violation of Article 2.4 of the UN Charter, which prohibits threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the Charter. And we all know there are two express exceptions to that in the Charter, which are only Article 51, self-defense, and Chapter 7, authorized use of force. So this falls in neither of them. Our events also are a violation of Article 1 of the UN Charter. One of the purposes of the United Nations is to maintain international peace and security. So the very purpose of the UN has been breached. breached. These breaches also mean we have parallel breaches of customary international law, of the principle of non-intervention, the right of the self-determination of the peoples of Ukraine, the principle of non-use of force that's in customary law in parallel with the UN Charter. And just to also note that the prohibition against aggressive use of force is actually one of those norms that rises to the use of Kogan's level. It's up there with genocide. So this is actually, it's a violation of a peremptory norm of a general international law. So it's actually at a level higher than the UN Charter. So I'll stop here for now.
Thank you. Let me turn to Meg next. Meg, what has been the international community's response thus far? How have states and international organizations reacted to the Russian invasion of Ukraine?
Sure. First of all, thank you, Milena and PILPG, for organizing this really important event. And I'm thrilled to see that there are so many participants. This is really one of the most important events in international law in our lifetimes. I was doing a panel with one of my colleagues earlier this week at the law school, and he said to the students, you'll be telling your kids about this, unfortunately. So it's really important that we all pay attention to this and do our best to seek to address it. So I also just want to note that I'm speaking in my individual capacity, not in my capacity as a judge of the International Residual Mechanism for Criminal Tribunals. So one of the most important responses from states so far have been sanctions, right? We know that the NATO leaders have said that because Ukraine is not a member of NATO, NATO is not able to invoke its collective self-defense and to intervene directly. But many states, including the most powerful states, have invoked very fierce sanctions, unprecedented, really, sanctions in this situation. So for those of you less familiar with international law, sanctions are penalties imposed by one state on another in the hopes of stopping a state from further violating international law, sort of a basic definition. They're often designed to hurt the state's economy and or its finances and the finances of individuals as well, including leading politicians. So Western states have frozen the assets of Russia's central bank, limiting its ability to access about $630 billion in its reserves. The US, EU, and UK have banned individuals and businesses from dealing with the Russian central bank, finance ministry, and wealth fund. Several Russian banks have been removed from the SWIFT messaging system, which enables the smooth transfer of money across borders, and will therefore delay payments to Russia for exports, in particular of oil and gas. Russian banks' assets have been frozen, so companies there can't raise, finance, or borrow money as easily. And Russian political leaders and individuals, including wealthy business people close to the Kremlin, who are often referred to as oligarchs, have had their assets frozen and are subject to travel bans. So those are a few of the sanctions. The US, UK, and Canada have banned all Russian flights from their airspace. And there was a report that Canada just stopped a flight, private flight with a couple of Russians on board from entering. And it's also worth noting that there have been some sanctions against Belarus as well, which seems to be joining in this conflict on the side of Russia. So those are some of the sanctions. Others can chime in with others, perhaps. There's also been very loud criticism by many, many individual states, and importantly, the United Nations General Assembly. So as many of the viewers no doubt know, Russia is a member of the Permanent Five in the Security Council, which means that it can veto any resolution condemning the attack in the Security Council, and indeed it has done so. But the General Assembly has entered into an extraordinary session, and the Assembly, which has 193 members, adopted a resolution deploring, in quote, the strongest terms, Russia's aggression against Ukraine, with a vote of 141 to 5 and 35 abstentions. There were 3 days of public statements during the General Assembly's special session. It was an emergency session, highlighting the mounting international alarm over Russia's actions. And it's worth noting that some of Russia's allies, including states like Cuba, Iran, and Nicaragua, abstained. And the states that voted against the resolution alongside Russia were Belarus, Eritrea, North Korea, and Syria. So interesting company there. Another response is that NATO has been bolstering its defenses, which I think Yvonne already mentioned, providing additional weapons to Ukraine, including air defense related weapons. So far not acceding to Ukraine's pleas for actual engagement in protecting the airspace, but providing weapons. And they have also deployed thousands of combat ready troops to Ukraine's NATO neighbors, including rapid response forces, land, air, maritime, and special ops forces, in the first ever deployment of NATO forces in collective self-defense, right? So this is a really important moment for NATO. Another response has been that many private companies have pulled out of or stopped interacting with Russia, including companies like British Petroleum and Shell, which have divested or exited Russian operations. Companies like IKEA, H&M, Toyota, Spotify have all paused, suspended their businesses in Russia. And then last but not least, I'll mention a very important development that I think we're going to continue to talk about going forward, which is that 39 states parties to the International Criminal Court have now referred the situation in Ukraine to the ICC. There was actually already an open preliminary investigation into the situation based on, although the Ukraine is not a member of the ICC, it had made a couple of declarations accepting the jurisdiction of the ICC over some specific situations, but then also over crimes, international crimes committed on the territory of the Ukraine from 2014 into the future, so to the present and going forward. So this declaration enables the ICC to exercise jurisdiction now that the situation has been referred to the court and the ICC prosecutor has begun actively investigating the situation. So the ICC has jurisdiction over war crimes being committed, crimes against humanity, and genocide. It does not have, and I know we'll talk about this as well, it does not have jurisdiction over the crime of aggression, for which both the aggressing state and the victim state must be states parties to the statute. So if the crime of aggression is to be addressed, it will have to be in a different forum, but the ICC potentially has the ability to address those other crimes. And I'll leave it there because I know we're going to talk about accountability in more detail. Those are just some of the international responses, but I'm sure others will chime in with others.
Thank you, Meg. My next question then is for Ambassador Rapp. There are so many international law issues related to the conflict, from use of force to accountability. Can you sort of briefly walk us through some of those issues? And I really want to combine this actually with one of the questions that just came in, and it has to do with preemptive self-defense. Part of Russia's justification rationale for the use of force in Ukraine might be that Russia is essentially saying that this is a preemptive strike because there were attacks on Russian citizens in Ukraine, or there could be attacks on Russian citizens in Ukraine. So could you talk a little bit about use of force, preemptive self-defense, some of the most relevant international law issues related to the conflict?
Well, thank you for that very broad question. And I think a lot of the foundation has been laid by my colleagues in regard to this. But as was noted by Meg, the ICC doesn't have jurisdiction over the crime of aggression. The Security Council could act, but obviously the Russians have already vetoed efforts to do that. There is a proposal by my good friend Dapo Akande, who's the British representative on the International Law Commission, to establish a special court specifically on aggression and to take advantage of the precedents of both Sierra Leone and Cambodia, where essentially Ukraine could request it, the General Assembly could approve it and establish essentially a treaty-based court with the United Nations and enforce the charter, provision 2.4. And if there were such a court, it could deal with this issue, and there wouldn't be head of state immunity because it would be an international court. Now, obviously, that whole thing would have to be built. Many would say it would be duplicative of the ICC, which is dealing with the atrocity crimes, genocide, war crimes, crimes against humanity. But that's where any issue of the preemptive self-defense would be litigated specifically. Now, frankly, most of us don't think much of those arguments. There was certainly going to be an effort, and we knew it, by Putin to create all sorts of pretext, almost like Hitler did, on August 31st of 1939 before invading Poland, riding out some guys in uniforms, and it looked like the Poles were attacking Germany. He wasn't able to get away with any of that. And it was, in fact, I think wisely, the U.S. was broadcasting the intelligence that was being received. So this particular, whatever may have occurred, wouldn't have justified at all under preemptive self-defense Russia invading the sovereign state of Ukraine. I mean, full stop. I mean, that's a laughable defense. But it would, to have it decided, you need a court. Now, on to the atrocity crimes. There we're talking genocide, war crimes, crimes against humanity. And as Meg said, Ukraine made 2 declarations as a non-party. They should have probably gone ahead and ratified the ICC. That's what I recommended when I visited them in 2014. But they made these declarations, and then it was up to the prosecutor to have a preliminary examination. And then, unless there was a state referral, the prosecutor had to go to the court, to the judges of the pretrial chamber, and get approval. And the prosecutor, Fatou Bensouda, in 2020 said she had a good enough case based upon Crimea, based upon what was happening in the Donbass, to go forward, but she didn't have the resources, so she hibernated. But that declaration, those declarations was open-ended. Basically, any of these atrocity crimes committed from November 2013 to the president onward are under the jurisdiction of the ICC. And now with 39 states led by the UK sending in a state referral, the prosecutor can now proceed with the investigation, and he has announced that he is doing that. And obviously in that, I mean, one would say that's a challenging thing to do, but he does have the support of the sovereign state, obviously a sovereign state that's under attack. You don't have that in other places. I would note, and it's another mechanism, this morning, the Human Rights Council in Geneva, by a vote of 32-2, in that case, it was Russia and Eritrea voting no, established a commission of inquiry on the human rights law violations being committed in the territory of Ukraine, including any of those that are also international crimes, and asking for determination of responsibilities, and also specifically asking that this commission maximize the possibility of the admission of its information in future legal proceedings in national, regional, or international courts. So we have that entity with 3 experts to be appointed and a staff that's going to be digging into this that can actually feed into the ICC process. But finally, I would note, but before I go there, I'd also note that civil society and open source investigators and others are also developing very strong evidence. And indeed, on none of these situations, even where the ICC has jurisdiction like this one, can you rely on that court alone. It has only 77 investigators and 14 places to investigate. That's a small town police. And so it has to rely on material that's been brought in by others, and that's abundant. I would say, just in regard to the allegations of war crimes, and many people said, well, why didn't the prosecutor do this already? Well, what's happening today, and what we've heard described, what's happening as we speak, is bad things happen in Luhansk and Donetsk, certainly. But what's happening today is 100 times worse. I mean, you go to Kharkiv and the school 17, school 75, school 118 destroyed, hospitals attacked, city council blown up, now a nuclear power plant attacked in a way that could have endangered all of Europe. Clear violations of the laws of war. Now, as a former prosecutor of Charles Taylor and at the Rwanda Tribunal, proving war crimes, law and conduct of hostilities has been a challenging thing at most tribunals. that's usually because the acts are being committed by proxy forces, or they're being committed over in the next country. They involve sort of action by, thugs going out and, like the Interahamwe with machetes. And so you've got to connect it. Well, here you're talking about a structure of power that leads straight up to Putin. There's just absolutely no question. He's the guy behind this. He's making the orders. He's fully aware of exactly what's going on. Even his own defense secretary rolled his eyes when he talked about, the nuclear alert. I mean, this guy is responsible, and it is possible, I think, with the pattern evidence that's going to be developed, and for heaven's sakes, we sure don't want things getting worse, but if they continue this trend of doing like they did in their own country, in the region of Chechnya and Grozny, of flattening and carpet bombing the city, if they do what they did in supporting the Syrians in Aleppo and Daraa, you will have, based upon that, rather solid, extremely solid evidence of war crimes, just the pattern. And so there is frankly nothing to prevent the ICC from seeking an arrest warrant of Putin in the next 2 or 3 months. Now, if they do that, what will that mean? I mean, this guy doesn't do a lot of travel. He doesn't even come within, 10 meters of his own staff. So, it's obviously going to be difficult to put him under arrest, but he will become an international pariah. He won't be going to any summits. He won't be able to visit any of those tens of billions of dollars of assets that he has abroad. And as in the case of Milosevic, even in the case of Bashir, where it took 9 years, eventually people that are under those kind of warrants end up being dispensable in their own country. And so it would have that effect, but it would be a long time before anyone was in custody. Now, I would note that, one of the issues here, and I was on a debate last night in Al Jazeera in Doha, and there was a Russian representative there who, like he was quoting from the State Department, said, why, Russia is not a state party to the ICC, therefore, there is no jurisdiction. And that was an argument that, fortunately, I never vocalized when I was ambassador at large, but it has been a traditional position of the United States. It's wrong. The ICC has territorial jurisdiction. The countries that have ratified it have basically said, ICC, you can take cases on these crimes from us. It's like I murder somebody in London, and then I say, oh, you can't touch me. No, the British can try me anywhere they want to. And if you commit crimes, even if you don't enter the country, but if you cause crimes to be committed in a country that's under the jurisdiction of the ICC, you're responsible, and that's within the sovereignty of Ukraine. And they said, we want our sovereignty exercised in that way. Now, I'm pleased in that regard and want to emphasize that, as I understand it, Senator Graham is proposing a resolution in the Senate calling for full U.S. support of the ICC case against Russians for the actions potentially against Russians, of course. It's evidence still has to be proved, but in any case, he's asked for the U.S. to support it, and as I understand, the direction's been given to the State Department's legislative arm to say we support that resolution. So the U.S. I think has crossed that particular Rubicon, and it's about time, because it was never a very useful argument. Your only argument when the ICC is coming after you is to say, that you're prosecuting it yourself. Or that it's not a grave crime, or that it didn't happen. And in this situation, none of those 3 things apply.
Thank you. Now, we are receiving some excellent questions through the question and answer feature here, so we're going to turn to those next. I know we're all dying to talk about the crime of aggression, but before we get there, I do think that there's an interesting question about sanctions. Meg, you talked about sanctions. One of our audience members is asking about the legal basis. What is the legal basis for example, seizing or freezing the foreign assets of Russian tycoons? We know the Security Council is paralyzed. It's not the Security Council, but where do states get the legal basis for doing this?
So others can weigh in on this as well, but I think at least one of the ways that they get a legal basis for doing this is the countermeasures provision of international law that enables states to respond to illegal acts with acts that would otherwise not themselves be legal, but that are justified as responses to the initial legal act of the wrongdoing state. So I don't know if others want to add to that.
I would also add, domestic legislation throughout various countries that enables country presidents, for example, to impose sanctions on individuals. We've certainly seen that in the United States, and I'm sure other countries as well have similar types of legislation.
Right. I'll just add there, the Global Magnitsky Act is one that in the United States, we are permitted to impose very harsh sanctions on individuals who are believed to be violating human rights in a significant fashion.
Thank you. Now, next, we're going to turn to the crime of aggression. And I'm going to start with Jennifer first. The question, one of our audience members has asked about the crime of aggression as a leadership crime, and how would one hold someone like Putin or other senior leaders from Russia accountable if the ICC has no jurisdiction? So I would actually invite you, if you want, to just talk a little bit about ICC's limited jurisdictional regime over the crime of aggression. How is it that the ICC does have jurisdiction over war crimes or crimes against humanity, but not aggression? And then if you have ideas about where someone like Putin could be prosecuted for the crime of aggression, and then I will open it up to our other panelists as well, because I know this is a very important topic, and I'm sure you have other thoughts to contribute on this. So Jennifer.
Great, thanks for that. So just to start off, let's be clear, we've had an act of aggression. So that is the act of state of aggression. And I saw in one of the questions, someone said, what about Belarus? So they're allowing their territory to launch the act of aggression. So they are complicit as well. In terms of the crime of aggression, you need political or military leaders who initiated the launch of the act of aggression, and we have those as well. So we clearly have the crime of aggression, and we can say the crime of aggression is occurring. So the next question is, where can this be prosecuted? So the ICC unfortunately doesn't have this jurisdiction. We actually have the US to thank for this. In Kampala in 2010, the US delegation carved out non-states parties of the Rome Statute, so those not parties to the Rome Statute. Otherwise, you might have jurisdiction through, Ukraine having become a state party, et cetera, but we don't have that. And then France and UK further narrowed the jurisdiction in 2017 in the activating resolution. Just pointing out the hypocrisy of three of the allies at Nuremberg, which spearheaded prosecutions of aggression. That was the key focus of the Nuremberg Tribunal. It was not on the Holocaust, it was on the crime of aggression. Three of the allies limited the ICC's jurisdiction. So the easiest thing we could actually do is amend one sentence of the Rome Statute, rather than creating a whole new tribunal. So we do have a tribunal, we have crime of aggression on its books, and it would be a simple amendment. Now I know getting the political support for that is not so simple, but I'm just saying that is a simple amendment. Ambassador Rapp referred to a crime of aggression tribunal. So we've seen a few proposals out there now. So if the Security Council is deadlocked, then next natural body to go to would be the General Assembly. As Stephen mentioned, we have the precedent of Sierra Leone Special Court, Cambodia Tribunal, formed between agreement between the UN and those countries. So here we could have an agreement between UN and Ukraine to create an aggression-specific tribunal. I think that is, the better way, although I think actually the ICC is the best positioned to handle this. You could have an EU Ukraine created tribunal. Our model is the Kosovo Specialist Chambers. And I've seen this proposal that I think Dapo is circulating. That sounds more like states coming together to recreate Nuremberg. Which is a different variant, I think raises concerns of selectivity. So all of these are to get Russian aggression. And honestly, if we believe in the crime of aggression and we believe in the International Criminal Court, we should have all states party to the International Criminal Court and ratifying the amended statute, which includes the crime of aggression. And then we really would have enforcement of the core norm of the UN Charter, Article 2.4. And all states parties to the Rome Statute could take this opportunity to reflect on the importance of the crime of aggression and ratify the crime of aggression amendment. only one last sentence. We do have potentials of jurisdiction through domestic legislation. Ukraine and Russia have the crime of aggression on their books. In any domestic courts, you're going to have immunities issues that don't arise at the international or hybrid level. So this isn't maybe the preferred way to go, but to point this out, and there are about 40 states that have domestic crime of aggression legislation, either the Nuremberg model or the ICC model on their books. Some have universal jurisdiction. So that is also out there. So those are the potential ways. To the question, how do you get Putin to The Hague? These are a number of ways. It's complicated. First, we have to create the jurisdiction. So that's kind of step one. But I agree certainly with Ambassador Rapp that I don't think Radovan Karadzic or Ratko Mladic or Slobodan Milosevic or Charles Taylor ever thought they would see a court. So all things are possible in the field of international justice.
Let me open it up to the other panelists, but in addition to talking about aggression, let me ask you to also think about the following question. And I think this is a really important question, especially for us from the US. What do you think about the arguments we see advanced by Russian sympathizers, which basically compare the Russian acts of aggression now to US military actions throughout the world to replace unfriendly regimes? So for example, in the Dominican Republic in the 60s, in Grenada and Panama in the 80s, in Iraq in 2003. And I think it's fair to say that some throughout the world see an essentially, a US hypocrisy on this issue, where when it's the US using force, it somehow is okay. Whereas when it's another world power like Russia, then it's not, and then it's a blatant violation of international law. So I think it's also important for us to think about that issue as well. So with that,
and indeed, I'm happy to talk about the inconsistency, but understand the major motivation that brought many to opposing broad application of the crime of aggression was the possibility that there would be a genocide or war crimes against humanity in a massive scale, and the Security Council would be blocked, and you'd need to act. In other words, a situation like Obama had with the red line, which many of us hope he would have crossed, when the chemical weapons were used, and Russia wouldn't support any action. The question was, would there be sort of some kind of intervention at that point? Things that Trump later did in a very small way. And so those there was that motivation, and perhaps in light of the need for consistency, though obviously can create a really difficult situation where you do have a tremendous horror. Better that the law would apply equally to everybody. In that regard, I would note that Harold Koh, my partner in leading the U.S. delegation in Kampala, has, on the behalf of the Ukrainian government, going to the International Court of Justice. We'll have a hearing next week on a rather interesting way to bring this issue before the court. Putin, sounding like a very bad law professor, talked about there was genocide being committed against the Russian population. And that was one of the things that motivated him to do essentially humanitarian intervention by bombing schools and hospitals. But that issue that's caused Ukraine to file against Russia under the Genocide Convention, one convention that they both ratified and unconditionally, and then to seek a determination that what Russia is doing is unjustified by the Genocide Convention, and having then provisional measures that they then withdraw because it's not consistent with any right that they might have had to intervene because of these atrocities, or no such right exists. And so that will sort of bring that issue squarely before us. I would note there's one other way that the ICJ could get there, though it sounds a little weak. The General Assembly, which clearly has this 141-5 majority to do it, could vote for an advisory opinion of the International Court of Justice on the question of aggression under 2.4, and litigated like Kosovo independence, or like the Britain and the Chagos Islands and Mauritius, it would be an advisory opinion, and even if it's decided that in the way we'd like it to, it would take probably several years, and in the end would be advisory, and the only way to enforce it would be through the Security Council. So at least the issue could be litigated in that way, and it would probably be relatively easy to get such a vote. Most of us, however, those of us that have been prosecutors, want to have something that's really going to bite, and an advisory opinion is not that.
Thank you. Yvonne?
Yeah, I thought I would just address this point that, just because there may have been violations of international law in the past, some of those have been roundly, criticized and been called to have been violations of international law. Some, the law has developed further in different regards. And I would also say, just because there may have been a violation of international law, another concept or agreed upon principle of international law is, for example, just because one country commits a genocide doesn't authorize us to commit a genocide, right? So that sort of logic doesn't really appeal to me. And I would say that also, one of the things that I find interesting here is Putin's effort to put his acts into international law language, but also in ways, as even a comment has mentioned, in ways that I think we as law professors and other practitioners of international law would say are just fundamentally wrong, right? That nobody would agree to. For example, this point about self-defense, right? And Jennifer touched on this earlier, right? Just because your neighbor said, they're going to have NATO, supporting them in the future, that is not a basis for self-defense under Article 51 of the UN Charter, right? Putin has put this in terms of sort of a preemptive self-defense, right? Preemptive self-defense is, to the extent that it is recognized, is for imminent attacks that are coming, right? It has been recognized in the context of, we really know that a nuclear bomb is, a warhead is pointed towards us and is going to be launched, and in which case the only alternative we have is to act or we will be destroyed, right? That is the usual conceptualization of preemptive self-defense. So I would say another thing we have to look at is sort of the twists and the way that international law is being misused in the way that Putin is characterizing his own actions here.
Thank you. Meg?
Yeah, I would just add, sort of echoing Yvonne, that, while certainly I'm not going to be an apologist for past US actions, I think a lot has changed in international law and international relations in the past couple of decades even. And one of the things I think that we're really seeing the effects of is the rise of international criminal law as a discourse in international relations. And it's been really remarkable, I think, to see how quickly people started talking about criminal accountability in this conflict in a way that, has not been the case in the past. And I think that we have to pay attention to this development and be very careful about it. On the one hand, the International Criminal Court has been the subject of a lot of criticism lately for a variety of reasons, some of them fairly well-founded. But now it's being invoked as, a key potential mechanism for addressing what's happening in Ukraine. So that, I think, has been a really important shift. The other thing that we have to pay attention to, though, in this regard is the tension that has always been there and that has always been part of the debates about the use of international criminal law in these kinds of contexts, which is the debate or the tension between peace and justice. Right. So on the one hand, many activists NGOs say that there can be no peace without justice. And we have, in fact, an organization by that very name, No Peace Without Justice, that's been active in this field for a long time, since before the Rome Conference. And on the other hand, arguments that the possibility of criminal accountability for somebody like Putin may leave him with little option but to entrench himself forever in power and to really hold on to power at all costs. And without taking sort of a position on this, I just wanted to point out that tension, that as we're all talking about, the importance of criminal accountability here, we have to also be alert to, the effects that may have on the conflict itself and on the suffering that is taking place.
Thank you. And I know Jennifer might have another thought on this.
Yeah, so I guess going back to your original question, Milena, I somewhat endorse the critique that we have to be a little concerned about selective justice. I mean, it's a problem for the whole field of international justice, where we have created tribunals, for specific situations. And then, for instance, the US can get behind them, but doesn't get behind the International Criminal Court as a whole. So if we have a tribunal to prosecute, Russia, this situation right now, it does bring up these kinds of questions. So the better approach would be empowering the International Criminal Court, a multilateral tribunal, to be able to look at all these, and all states endorsing, ratifying the Rome Statute, the amended version. But just to go back to maybe Stephen's mention of humanitarian intervention. Oh, the US can't, ratify the Crime of Aggression Amendment, so we do humanitarian intervention. It is built into the crime of aggression definition that you need a manifest charter violation, like a super clear charter violation. And, there is a school of thought that humanitarian intervention, widely accepted, is maybe not strictly legal, but sometimes imperative. So that many will argue it's in a gray area. So it's basically, if you have an okay legal theory, it isn't a good ICC case. And that's kind of what is built. So the crime of aggression at the ICC is quite conservative. If you have a plausible legal theory about your drone strikes, et cetera. And just to say, I'm not going to justify the US historically, but when the US has a plausible legal theory, these do not make good ICC cases, or they would not make good ICC cases. And that is because not only do we have the Rome Statute's general gravity threshold, we have the special threshold built into the definition of the crime of aggression with the manifest charter violation, which we're seeing out of Russia. So just to try to make that differentiation.
No, thank you for those comments, Jennifer. And I think Ambassador Rapp also already alluded to this, that the ICC, even if in theory it has jurisdiction, in reality it has very limited resources, a limited number of investigators, limited number of prosecutors, limited resources. And so even if in theory it could go do X, Y, and Z, in practice, it really can only do X. And so Jennifer, I'm glad that you're mentioning that basically these more difficult legal issues don't really lead to good ICC cases. If you're the prosecutor, you're looking for cases where it's going to be, I'm going to say a slam dunk conviction, but it's going to be an easier conviction than if you're operating in a gray area. We could talk about the ICC for a very long time, but we are running out of time. So I really, over the last few minutes here, I do want to talk a little bit about the role of NATO and perhaps the role of the EU. So one of the questions that came in has to do with NATO. Dialogue and cooperation between NATO and Ukraine started when newly independent Ukraine joined the North Atlantic Cooperation Council in '91 and the Partnership for Peace program in '94. And what's also very important for NATO-Ukraine relations is the declaration of the Bucharest NATO summit in 2008, paragraph 23, indicating for the first time an open door policy for Ukraine and Georgia. We didn't really talk about Georgia, but Georgia, obviously the former Soviet state, has also been the subject of basically Russian military acts, to say the least, some 12 years ago. So how do you see the role of NATO? we know as of now, Ukraine is not a NATO country, but what if Putin attacked one of the Baltic states? And even if he doesn't, how do you see NATO stepping in here to perhaps, not to say resolve the conflict, but try to mediate or try to at least deter Putin from further action? So let me go with Ambassador Rapp first.
I think it's extremely, the decision about whether Ukraine comes into NATO is a decision yet to be made. And certainly the United States could say, this is too far away, it's too difficult to do. Ukraine's entitled to defense, but expanding the network that far, we're not going to do. And who knows whether this particular bridge would be crossed. And I think what we see now, the prospect, and we hope it's not going to happen, but that Russia could take Ukraine and bring itself right up to the border of several NATO countries. And then what happens when there's an insurgency, as we would expect, and hot pursuit and a variety of things, we could find ourselves under Article 5 needing to defend. And I think that makes it all the more important that we keep that from happening. I mean, as a matter of national security, the continued provision of defensive weapons, the Stingers, the Javelins, the Turkish drones, et cetera, to knock out the offensive weapons, to make this much more difficult, to lead to a situation where Ukraine, there may be a negotiation, who knows, and obviously the idea that Ukraine would surrender its independence is a non-starter, as the president has said. But there could be a resolution here. We'd much prefer that, and not to have the NATO border moved, because I don't think there's any question that if we saw an all-out attack on the Baltics or on Poland, the United States would be obligated to defend, and we would be in a situation of potentially moving to World War III. So, and these are things that have to be done very carefully, but the best way is to prevent it from reaching that border, and that's why I think NATO is so extremely concerned, and why a variety of countries like Germany, who had been not getting up to 2% on its defense budget, et cetera, suddenly for at least 1 year doubled their defense budget and is providing these defensive weapons when a couple weeks beforehand they thought 50 helmets was enough. And so, there really is this concern about the defense of the West, and we really have to do everything we can to keep Russia from winning this one.
Thank you. Would anybody else like to weigh in on this one, and perhaps also the role of the European Union? Ukraine is not yet a member of the European Union, but what if it were? Would that change anything, in terms of the perhaps military response to this? Well, that's also a tricky one. Perhaps we can close with the following question, going back to this theme of accountability. What do you think are the prospects of setting up a special tribunal, whatever that looks like, to prosecute the crime of aggression in Ukraine? Any thoughts as to how that could happen outside of the ICC?
Anyway, as a person that sort of suggested this idea 2 or 3 days ago, I actually think that it's probably too slow to establish a whole court and to get everything stood up for this kind of acute situation that develops by the hour. And the fact that we have the ICC on the job, at least for the atrocity crimes, and where the Russians so clearly appear to be committing atrocity crimes, war crimes, and crimes against humanity, to be frank, that I think that putting all our efforts into success there probably makes more sense, even though I'd love to have a determination on the aggression issue. I think that probably isn't practical, and it won't get the tens of millions or hundreds of millions of dollars that it would take to actually do this kind of tribunal as a one-off freestanding aggression tribunal.
Yeah, and I'll jump in just briefly because I think Jennifer and Stephen have both spoken to this. If the ICC were to have jurisdiction over this, I thought one hopeful thing that we've been seeing in the news is that because so many states referred this matter to the ICC right on the general situation that is anyway. It looks like the prosecutor is going to be seeking additional resources and donors, and it looks like there might be some support for that, right? This seems to be heralding a new day and a new dawn, and it's sort of some new interest in the International Criminal Court, and sort of bolstering, the founding premise of it, which was to have a permanent court. We have this permanent court. And I see that the comments even from Jennifer and Stephen are sort of, we have this permanent court. And that was sort of what it was there for. It's there.
Yeah, I'll also just add that I think it's given how many states are declaring this to be aggression, I'm not sure how important it is to, as Stephen said, set up a whole tribunal, and with the potential cost and timeliness, it would be in many ways really an important step for the global community if that were to happen. But I also think the fact that it's already being so widely recognized as being aggression goes a long way in that regard. And if the ICC is able to prosecute some of these other crimes and hold people accountable, the accountability for those crimes may also make it less important that they be specifically held accountable for that crime.
I know we're out of time, so I'll just say in like half a second that first, I agree fully with Yvonne. This is, a resounding endorsement for the ICC, right? We've never had, we used to have referrals, one state, then we had 5 states refer Venezuela. So 39 is just unprecedented. And we hope the funding follows that. But just also in response to Meg really quickly, I mean, yeah, all these organizations are recognizing this was an act of aggression, et cetera, et cetera. It's very different to prosecute the crime of aggression. So, and it doesn't happen, it's not going to happen right now. And right now, one needs to investigate and maybe try to deter by the communicating, the ICC's out there, it's looking at these crimes, there is jurisdiction, if that creates any deterrent value, we hope it does. But just to say, I think we should also explore, the possibility of prosecution of the crime of aggression. I mean, that's where this whole field started at Nuremberg. It was actually the crime of aggression as kind of prosecutions was the foundation of the field of international justice at Nuremberg. So I'll end there.
Let me make it clear. I favor it if we can get it. I'm just wondering about the political will to establish it. It'd be a good idea, maybe a little smaller. It's not that complicated. Maybe this is the one to really clarify the law.
And I also agree. I mean, especially if it's long term, right? If we can do it, there's no rush.
Right.
Well, thank you all. That's all that we have time for today. Thank you for joining us. To our audience members, thank you for submitting all your questions. The webinar recording will be available on the PLPG website and shared with all the attendees on Zoom via email. The event was part of the PLPG Thought Leadership Initiative series. Thank you very much to our panelists for taking the time today to talk about the recent developments in Ukraine and Russia and providing your analysis of the legal issues that have arisen. I encourage everyone to follow our Thought Leadership Initiative and join us next week on March 10th from 12 noon Eastern Standard Time to 1 p.m. for our next event on the impact of the war on Yemen's justice system. Thank you all.
Thank you.
Thank you.